Good day everyone. Today is another day and today we tackle about Chapter 9 Void and Inexistent Contracts under the provision of a Civil Code Article 1409 to Article 1422 presented by Proof 10. So before we start, I want to introduce myself. Hi, I'm Ian Entrata and I'm your first speaker. So guys, listen carefully and critically because here are the questions we will ask and you can need to answer them. So let's start. We are done with rescissible, voidable, and unenforceable contracts. For the finished coverage of a contract, we are now in void contract. So guys, before we start the Article 1409, let us first proceed to what is void and inexistent contracts. Is void and inexistent contracts. Pares lang ba itong void and inexistent contract? Pares lang sila essentially, but let us technically about it. Pag sinabi inexistent, may isa, dalawa, o lahat ng elements of a contract ay hindi present. And pag void naman, present naman pero illegal. And there are also saying that your agreement is entered by minors or illegal activities, it is also rendered as void. And just always remember that general goal of a void contract. And kung isinahalang-alang ng inyong client na walang legal na batayan na pwede nyo nang i-claim yung contract nyo, it is also void. Let us have a example. Mark and Anthony. Let's say Mark it is a drug dealers and Anthony is buyers. So in the very beginning, it is a void because the subject matter is illegal. Sa Article 1409. First is those whose cause, object, or purpose is contrary to law, morals, good customs, public orders, and public policies. So, it is a void pero kasi meron kompleto yung elements pero illegal. And dito, alam na natin kung anong yung cause, object, or purpose mo is contrary enumeration. So, we all know the effect which is illegal and we can say na or render is void. And next is those which are simulator or fictitious inexistent contracts. Kasi wala naman talaga kayong kontrata pero we can make it na meron pero wala naman. And remember the pagkakaiba ng absolute simulation and relative simulation. Next is those whose cause or object did not exist at the time of a transaction. Inexistent contracts. Di siya nag-consist, kulang na sa element. And don't confuse the future object. The future thing can be the subject of a contract. Okay lang yon na mangyayari pa kasi siya sa in the future. But if did not exist at that time, ibig sabihin, wala na talagang pagkakataon in the future na mangyayari yun. So, next, example, may na-import akong product coming from China. They're in now to transit in Philippines. And may client na ako na bibili nun. So, kasamang palad, yung part ko na sinasakyan ng product namin or yung subject matter namin ay lumubog. And so yung subject matter namin is nawala na. So, hindi na magko-consist. Wala na. And next is those whose object is outside the commerce of men. Inexistent. Kasi wala ka naman talagang object. Let's say, nakita mo yung moon, sabi mo, akin yan. Outside the commerce of men. Hindi pwede. And next is those which contemplate an impossible service. Inexistent contract. Dahil wala ka naman talagang object. Nag-usap kayo, nababaril mo siya. Again, may dalawang impossibility, physical and legal. Legal, if babarilin mo siya and you have known generally na papatay mo siya, it may be homicide. And physical impossibility, you can hold your breath in 15 days. It is also physical impossible. Next is those were in the intention of a party relative to the principal object of a contract cannot be uncertain. inexistent pa rin kasi wala ka pa rin object. So, hindi mo naman kasi maintindihan kung ano ba talaga yung uncertain or interpretation. Kahit baliktarin man kayo, hindi nyo pa rin makukuha yung uncertain of intention. And next is those expressly prohibited or declared void by law. Void contract because batas na ang nagpapabawal. No. And next is these contracts cannot be ratified. You can claim something is void. Hindi kayo pwede magkasundo na pwede na to, kahit illegal, pwede na, kahit kulang, pwede na, hindi pwede. You cannot ratify a void and inexistent contracts. Neither can be the right to set up by the defense of illegality be waived. Ibig sabihin, hindi mo pwede i-forgo o pwede sabihin na hindi na kita tatanungin about dito. Tuloy lang natin. I will waive my right to raise the defense against of illegality. Tuloy lang, I cannot will and just always say illegal from. And meron kang case of defense against of illegality at hindi mo pwedeng pakawalan. Guys, proceed na tayo sa kung paano naiba ang voidable contracts sa null and void na kontrata. A null and void contract is considered dead on arrival because it was never valid because of the contract has no legal effect. This is different of having a contract invalidated. Contracts may be considered null and void for various reasons, generally because they are missing one of the more of the elements discussed above. There are some of the most common reasons. First is yung subject natin kanina or topic natin na if your subject is it is a illegal. And for example, if you sign a contract to launder money for an organized crime syndicate, but the other party breaches is terms wala kang legal o wala kang laban dahil yung kasunduan nyo is labag sa batas. And next is yung fraud. Sa Tagalog is panloloko. If a contract would be validated because one party got the other party to sign it by lying or concealing important facts. So, sa pagkakataon na yun, kung ang isang partido ay nahatulan na kanselahin yung kontrata nyo, it is a void contract. And for example, si Janelle, si Eric, si Prince, and si Sheila E. So, si Janelle nag-aalok na bilhin yung naka-autograph na poster ni Prince kay Eric. Ngunit, sa masusing pagsisiyasat, napagtanto nila na ni Eric na ang autograph ay hindi kay Prince, kundi kay Sheila E. Maaaring ma-void ni Janelle yung kontrata dahil sa maling paniniwala ni Eric sa pinirmahan daw ni Prince ang poster. Ngunit, nagpasya pa rin sila na ituloy yung contract dahil sa mas pan daw siya ni Sheila E. So, kahit voidable contract na yun sa kadilahanan ng pagkakamali ay itinuring pa rin valid at ipinagpapatupad dahil pumayag si Janelle sa deal na yun. We are now in Article 14.10. The Act states that the action or defense for the declaration of the inexistent of a contract does not prescribe. So, kung matatandaan nyo sa unenforceable contract, pag nag-declare siya na as a right of rescission, kailangan mo ng 4 years. Sa right of annulment, 4 years din. Pero dito sa Article 14.010, ang right mo is raised to defense ng isang contract na void and existent contracts na hindi ma-prescribe ng 10 or 15 years pang lumipas. And you can say that void naman talagang void kasi kahit hindi ako magbayad, void naman to And let's say the subject matter nyo is shabu. Void yan. Anytime you can raise the defense that is a void and inexistent contracts or the action of a defense will not prescribe. For example, manager of Alaska sells bear brand sa Pagsanal Falls, and manager of bear brand gives Alaska of money. So of course, the contract is null and void. But suppose Alaska refuses to return to bear brand the money, and stating that there is no wrong with the contract. So ano ang dapat gawin ni manager of bear brand? Dapat niyang gawin is magsampas ng aksyon sa korte na ideklara ang kawalan ng kontrata. And yung right ni bear brand is to bring the action that not prescribed. And the effect of this kind of contract could be curbed by prescription or by ratification. My last topic to be had is Article 1411 states that when the nullity proceeds from the illegality of the cause or object of a contract, it thus constitutes a criminal offense, both parties being in pari delicto. There shall have no action against each other, and both shall be prosecuted. Moreover, the provision of a penal code relative to the disposal or effects or instruments of a crime shall apply to the things or the price of a contract. This rule shall be applicable when only one party is guilty, but one party is innocent. So, the innocent party may claim shall be has given and shall not be bound to his promise. And so, ibig sabihin ng in pari delicto, parehas kayong may kasalanan. Halimbawa, si X and Y, may contract of sale kayo ng shabu. It is si X yung buyers and si Y yung seller. So, tapos si X is nag-pay kay Y ng 10 million na siya para sa shabu. And si Y naman, let's say, nag-deliver ng 5 kilos of shabu. After ng exchange, si Y, napagtanto niya na yung pera na 10 million na binayad ni X ay fake bills. And sa kabila naman, yung nakuha ni X from Y na shabu is hindi shabu, kundi tawas lang. So there are in pari delicto, and both constitutes a criminal offense. So ano mangyayari? Hindi pwede nilang kasuhan yung isa't isa kasi magmumukha lang silang katawa-tawa. And let's say na pumunta sila sa korte at sabi ni X na taos lang pala yung pinadala mo sa akin tas si Y naman is ikaw din naman yung binayad mo sa akin is peke. So walang ganon. Meron kasi tayong principle in law, those comes to court as a clean hand. So guys, hindi ibig sabihin ng clean hand ay pagpunta mo sa korte, kailangan mo maghugas mo ng kamay. Hindi ganon ang ibig sabihin. Ang ibig sabihin nun is pagpunta mo sa korte, kailangan ikaw mismo ay walang nilalabag na batas at wala kang kasalanan. And there are exemption to the rule of in pari delicto. First is the innocent party under the Article 1411 to Article 1412 of Civil Code. Gaya ng sabi ko, kapag innocent party siya, pwede pa niya ma-claim yung kung ano man ang nabigay niya. And next is the debtor who pays usurious interest under Article 1413 of Civil Code. We will discuss by the next reporter. And next is the part repudiating the void contract before the illegal purpose is accomplished or before damage is caused to a third person and if the public interest is subserved by allowing recovery under the Article 1414 of Civil Code by discussed by next speaker. And next, the incapacitated party if the interest of justice so demand. Under Article 1415 of Civil Code, we will discuss by next speaker. And next is the part of whose protection the provision by law is intended if the agreement is not illegal per so but merely prohibited, and if the public, the policy was be enhanced by permitting recovery. Under Article 1416 of Civil Code by discussed by next speaker. And last is the party to whose benefits for the law has been intended, such as in the price ceiling laws under Article 1417 of Civil Code and labor laws under Article 1418 to Article 1419 of Civil Code. We will discuss by next reporter. And for the next report speaker, I call on Kristen Reyes to tackle about Article 1412 to Article 1415.
Article 1412 states that the act in which the unlawful or forbidden cause consists does not constitute a criminal offense. The following rules shall be observed. Number 1. When the fault is on the part of both parties, neither may recover what he has given by virtue of the contract or demand the performance of the other's undertaking. Number 2. When only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract or ask for the fulfillment of what has been promised him. The other who is not at fault may demand the return of the following he has given without any obligation to comply his promise. Are the rules to follow in this article? Number 1, when both parties are in a state of pari delicto means if both parties are at fault or guilty in a crime, they won't be able to get back what they gave under the deal. They are unable to compel the other party to fulfill the obligation or pledge. If Cathy agreed to live as Pedro's common law wife, in exchange for Pedro's promise to donate a piece of land to Cathy. In this situation, Pedro's promise is an immoral conduct that does not constitute a crime. As a result, neither party can recover against the other, nor can they demand the fulfillment of the other's obligation. Number 2, if only one of the contracting parties is at fault, the contract will be voided. The person who is at fault is unable to reclaim the money he has given under the contract. He can't expect the other's commitment to be fulfilled. The person who is not at fault has the right to demand the return of what they has given without being obligated to keep his promise or pledge to the other. Article 1413 states that interest paid in excess of the interest allowed by the usury law may be recovered by the debtor with interest thereon from the date of the payment. A provision requiring the payment of usurer's interest is null and void. In an independent civil action, the individual who pays usurer's interest can be collect not only the interest in excess of what is allowed under usury regulation, but also the entire amount paid in interest. For example, Mary borrowed from her neighbor and agreed that the interest was 5%, but she paid more than the interest she gave so she could get it according to the law. Article 1440 states that with monies paid or properly delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished or before any damage has been caused to a third person. In such case, the courts may, if the public interest will thus be served, allow the party repudiating the contract to recover the money or property. When money is obtained illegally or unlawfully in the performance of an obligation, the courts may, in the public interest, allow in other party to recover the money from the party that unlawfully executed the duty. For example, Pedro agreed to invest $1 million in the buy and sell firm of his acquaintance. Pedro afterwards found that it was a swindling ring. As a result, he has unable to obtain his funds from his pal. Pedro has the option of suing his friend to get his money back. Lastly, Article 1415. Where one of the parties to an illegal contract is incapable of giving consent, the courts may, if the interest of justice so demands, allow recovery of money or property delivered by the incapacitated person. In this article, if the party who entered into an illegal contract is incapable of consenting a minor or insane, he must be allowed to reclaim the money or property supplied, but only if the interest of justice demand it. The matter is left to the court discretion on a case-to-case basis as there are not legal criteria in place. For example, in this article, Rodrigo, an unstable but wealthy man, paid Bong 1 million to keep Mark, who is suspected of murder, hidden. If the interests of justice demand it, the court may enable Rodrigo to reclaim the money he gave out under Article 1450.
Hi, this is Ms. Regine, your third speaker for today. And the topic that I'm going to discuss is all about Article 1416 to 1418. Article 1416 states that when the agreement is not illegal per se, but is merely prohibited, and the prohibition by the law is designed for the protection of the plaintiff, he may, if public policy is thereby enhanced, recover what he has paid or delivered. It means that the plaintiff can still recover what he or she has paid or delivered as long as the agreement is lawful and the prohibition are for the protection of the plaintiff. But it applies only to those contracts which are merely prohibited to benefit private interests. But it does not apply to those contracts void ab initio. Prohibited sale of land. Under the doctrine of pari delicto, the parties have no action to each other when they are both at fault. See at Article 1412. The rule, however, has been interpreted as applicable only when the fault on both sides is more or less equivalent. Article 1417 states that when the price of any article or commodity is determined by the statute or by authority of law, any person paying any amount in the maximum price allowed may recover such excess. A statute fixing the maximum price of any article or commodity, usually known as ceiling law or price ceiling, because this law prevents the profiteering in which is inimical to the interest of the people. Therefore, any excess payment made must be recoverable. For example, suppose by the executive order of the President, the price per kilo of rice of a particular brand and quality, specifically Gold Sun, has been fixed at 48 pesos. There is a typhoon when Miss Anna bought one sack of rice, so it cost 50 pesos per kilo, and she paid totally of 2,500 for it. But because of the ceiling law, she can still recover the excess payment she made, which is totally of 100 pesos. Article 1418 states that when the law fixes or authorizes the fixing of the maximum number of hours of labor and a contract is entered into whereby a laborer undertakes to work longer than the maximum, thus fixed, he may demand additional compensation for service rendered beyond the time limit.
Good day everyone, I am Erica Sevillano Polme. For today, we will tackle about Article 1419 to Article 1420. So what is Article 1419? Article 1419, when the law sets or authorizes the setting of a minimum wage for laborers, and the contract is agreed upon by which a laborer accepts a lower wage, he shall be entitled to recover the deficiency. In Tagalog, kapag ang batas ay nagpatalaga o pinahintulutan ang pagtatagda ng minimum wage para sa mga trabahador at ang kontrata ay napagkasundoan na kung saan ang trabahador ay tumanggap ng maliit na sahod, ang trabahador ay may karapatan na maibalik sa kanya ang kulang. No waiver of minimum wage. If a worker has consented to be paid less than the legal minimum wage, he is not precluding from recouping the difference. No worker or organization of workers may voluntarily or otherwise, individually or collectively, waive any rights established under this Act and no agreement or contract, oral or written, to accept a lower wage or less than any other benefit required under this Act shall be valid according to the law, minimum wage law. For example, the owner of a chocolate factory in Manila, A, signed a labor contract with B. When payday arrives, B reacts to the amount of money that he received because the amount that he received is only 380 per day instead of 481 pesos a day. So B can recover for the deficiency that he received from A. As stated in this article, when the law sets or authorizes the setting of a minimum wage for laborers and a contract is agreed upon by which a laborer accepts a lower wage, he shall be entitled to recover. Another example, John, an employee under Lee's restaurant, has voluntarily agreed under contract to receive 250 per day, a wage lower than the minimum wage fixed by the law. Regardless of that fact, he is not barred from recovering in the deficiency. So let's move on to the Article 1420. Article 1420, in case of a divisible contract, if the illegal terms can be separated from the legal ones, the latter may be enforced. In Tagalog, sa mga kaso na maaaring hatiin ang kontrata kung ang illegal na mga bahagi nito ay maaaring hiwalay sa mga legal na bahagi, ito ay ipatutupad. So these articles applies if a contract contains many stipulations and is not applicable if the contract's provisions are indivisible by their nature. When the consideration is full and single, the contract is indivisible. Therefore, if any portion of the consideration is illegal, the entire contract is void and unenforceable. The latter may be enforced if the contract is divisible or severable. That is, if the consideration is made up of many components and the illegal ones can be separated from the legitimate ones. This rule, however, is susceptible to the parties' opposing intentions. Example, a borrower executed a car mortgage using a forged title as collateral. The mortgage is void, but the loan is still in effect. Another example, Sen sells to some 1 case of sparkling wine and 12 sticks of marijuana for consideration of 500 pesos. Is the sale divisible or indivisible? The answer is it is indivisible because there is only one consideration, 500 pesos for the both 1 case or sparkling wine and the 12 sticks of marijuana. Is the contract void or not? The entire contract is void because even though the purchase of 1 case of sparkling wine is legal, it cannot be separated from the 12 sticks of marijuana which are illegal. Accordingly, no part of this contract thereof may be enforced.
Good day everyone. My name is Jefferson Sunose and I tackle Article 1421 and 1422. Article 1421. The defense of illegality of contract is not available to third person whose interests are not directly affected. Person entitled to raise defense of illegality. Third parties are not permitted to file an action to annul or challenge a contract that is void and unenforceable. If the contract is invalid or void, however, even a third party may invoke the defense of illegality or establish his illegality if his interest is directly harmed by the transaction. The defense of illegality in general, hindi po talaga siya available sa third person. Even if the contract is illegal, the defense of illegality ng contract na yan ay pwedeng i-set up ng mga tao who interest are direct affected. For example, ibinenta ni Harold ang kanyang parsela ng lupa sa kanyang asawa na si Margarita. Sa ilalim ng batas, hindi pwedeng magbenta ng ari-arian ang mag-asawa sa isa't isa. Ang nasabing pagbebenta ay labag sa batas at walang bisa. Kung si Charlie ay isang third person na tao, ay naging pinagkakautangan ni Harold bago ang transaksyon, maaari niyang questionin ang pagbenta sa kadahilan ng direktang epektado ang kanyang karapatan o interes. Ganun pa man, kung siya ay naging isang pinagkakautangan pagkatapos ng paglipat, ang pagtatanggol sa illegalidad ay hindi magagamit sa kanya. Article 1422. A contract in which direct result of a previous illegal contract is void and inexistent. Void contract cannot be novated. This clause is based on the criteria for a legitimate novation, and an illegal contract is null and void and so cannot give rise to the valid contract. Yung mga contract daw na direct result daw ng mga previous illegal contract ay magiging void and inexistence rin. Void or inexistence na kontrata ay isang kasunduan na nagsasagawa ng isang illegal na gawain ng isang walang bisa o walang bisang kontrata o walang bisa na kasunduan. Halimbawa, ang isang kontrata sa pagitan ng mga nagbebenta ng droga at mga mamimili ay isang walang bisang kontrata dahil illegal ang mga tuntunin ng kanilang kontrata. For example, nagbebenta si Optimus ng dilaw na Chevrolet Camaro kay Megatron. Ang dalawang partido ay pumirma din ng isang kontrata sa maling pagbili kung saan may karapatan sa Optimus na bilhin muli ang kotse sa loob ng 2 taon. Ito ay lumabas na ang yellow Chevrolet Camaro ay may karapatang pagmamayari ni Bumblebee at hindi ni Optimus Prime. Sa ilalim ng Article 1422, ang kontrata ng muling pagbili ay nakasalalay sa bisa ng kontrata ng pagbebentahan. Dahil sa kontrata ng pagbebentahan ay walang bisa dahil si Optimus ang nagbebenta at hindi siya ang may-ari. Ang kasunod na kontrata ng muling pagbili ay wala ring bisa din dahil ito ay nagpapalagay ng isang wastong kontrata ng pagbebenta sa pagitan ng parehong partido. Ang isang tao ay maaaring bumili lamang ng dati niyang naibenta. For another example is, gumawa ng kontrata si Mr. A kay Mr. B sa pagbebenta ng isang parsela ng lupa na ang katotohanan na isang illegal na nakuhang titulo ng isang lupa. Pagkatapos ay binenta ni Mr. B ang titulo kay Mr. C, na naggalaon ay nalaman ni Mr. C na ang titulo ay ng parsela ng lupa na binili niya ay illegal na nakuha niya. Maaari bang kasuhan ni Mr. C si Mr. B? Ang sagot niya na hindi. Maaaring i-demanda nila Mr. C and Mr. B si Mr. A dahil siya ang pinagmulan ng kontratang illegal na nakuha. Mula sa nakaraang kontrata, ang illegal na nakuhang titulo ay void. Hanggang sa ginawang bago kontrata ay void pa rin ang naturang bagong kontrata.